And we're all supposed to be equal under the law. Hello? But we're not. We're not equal. You know why? Some people can run for offices that you and I cannot run for. They're called judges. And you can't run for it. And they're called district attorney. And you and I can't run for it. But once upon a time, anybody could run for judge. And in fact, lawyers were forbidden to be judges. They could not be judges. They could not be elected judges. They couldn't even let them into, they wouldn't even let them into the courtroom. Bailiffs would keep the lawyers out. And they snuck in because they wrote people's wills on their last testaments, and then they had controversy, and so the lawyer had to come into the courtroom to testify as to the will of somebody that died, and some descendant is saying, I got cheated. And so that's how they wiggle their way back into the courtroom. And now they've created bar associations over the last 75 years and said only lawyers can be judges. This is nonsense. I tracked down the man that got the documents and printed the last copy of the original 13th. His name is Alfred ADASK. And I had to go to the hill country of Tennessee. And believe me, it was hot, dry, and I don't want to ever go back there again. Out in the middle of central Texas somewhere, someplace off from San Antonio. Here's my interview with Alfred ADASK, and it's riveting. Listen to this guy. Central Texas somewhere. I'm not sure where we are.
We're in the hill country.
They call it the hill country in Texas, with Alfred ADASK. Got hold and actually published, he says, more than 300, maybe up to possibly 1,000 or more of these books on the missing 13th Amendment. Alfred, tell me why Larry Dodge and the retired police officer Tom Dunn came to you with this information. Why did they bring it to you, and what did you do with it?
Tom Dunn and Larry Dodge were sitting around in a library in Belfast, Maine. Oh, back probably 1989, in that vicinity, approximately that time frame, 90, thereabouts. And they asked the librarian to bring them the oldest copy. They were arguing something about the Constitution. And they asked the librarian to bring them the oldest copy of the Constitution she had in that library. And that library went back at least into the 1800s, and I think it may have actually existed in the 1700s, if I remember correctly. She brought them the oldest copy of the Constitution they had, and they thumbed it open, and it had a 13th Amendment on it that they'd never seen before. And it involved titles of nobility. It prohibited titles of nobility, and it prohibited honors. And titles of nobility are to this day prohibited in the Constitution of the United States. They prohibit them for both the states and for the federal government. But this one not only prohibited the titles of nobility, it prohibited honors, and it provided a penalty. If you received a title of nobility, if you received an honor, you would forfeit your citizenship. That doesn't mean you'd be extradited and sent to another country. It just means that you could not hold public office, you could not vote. You were out of the political process if you took a title of nobility. The amendment was proposed about 1810. They started researching. They said, where did this come from? They'd never heard of it before. They started researching. Turns out this missing 13th Amendment was proposed about 1810. And they needed 9 states to ratify. And 8 states ratified by into 1812. And the War of 1812 broke out. Everybody forgot about the amendment during the war. And in the aftermath of the war, they didn't think about it until about 1819. And I think it was President Monroe at the time. The president said, what are we going to do about this amendment? Are we going to pass this thing or not? Because they'd had 8 states voted for it, and 4 states, 5, they needed 9, and they had, I think they needed 9, but they had 4 or 5 states hadn't yet ratified or commented on it. So they contacted all these states and said, are you going to ratify or not? The problem shows up in Virginia. Virginia apparently ratified. And it is believed that they sent notice of their ratification by publishing a new edition of their state constitution, which included a copy of the United States Constitution as an appendix at the back. And this new copy of the state constitution, this new version, this new federal constitution included the missing 13th Amendment. The law that ordered them to produce and publish this new edition of the state constitution with the federal constitution It specifically said they had to send a copy to the President of the United States, the Secretary of State, and to Thomas Jefferson. I think there were 4 people altogether. All right? But it is believed by Dodge and Dunn that it was by this means that they served notice on the federal government that they had in fact ratified this amendment. It's virtually inconceivable that they would have ordered the production of a brand new state constitution with a brand new copy of the federal constitution with an amendment that they didn't believe belonged there. And Virginia, of course, was the political powerhouse of the country at that time. Something like 4 of our first 5 presidents came from Virginia. It's inconceivable that Virginia would make a mistake about whether an amendment was or was not on the federal constitution. The problem is that when Dodge and Dunn went into the Virginian archives, they can't find any records from the legislature from that time period. They just seemed to be missing. It may be they can be found today, but they couldn't be found back in the early 1990s. The result was there's not absolute proof that Virginia ratified this amendment. So there's a debate. Was it ratified by 9 states or was it not ratified by 9 states? There's a debate. But what Dodge did, David Dodge, he took his van and he started traveling around the country. And he went from archive to archive around the United States looking for evidence of this missing 13th Amendment. And it turns out that he found it in, I don't know, 8, 10, a dozen different archives. I don't know how many archives he researched, but he found 23 or 26, I don't recall the number now, this information. You're asking me about things that were fresh in my mind 15, 20 years ago, and they're not quite so fresh today. But he found 23 or 26 states and territories that had published this amendment as ratified in documents that they'd published over a period from 1819 up until 1870 something. Over a period of more than 50 years, this amendment had been published off and on, not always at the same time, but 26 states and territories. If it wasn't ratified, it is almost inconceivable that these states could have published this amendment by accident. I mean, the first time one of the states published it by accident, the president or somebody said, "Hey, all you hicks out there in TV land, wake up! The amendment wasn't ratified." The word should go out. You can't propagate an error like this, or you shouldn't be able to, for 50 years. Nevertheless, it was published for over 50 years, and the result is a mystery. Dodge accumulated this information. He brought it to me in part because I was publishing a magazine called The Anti-Shyster. We were critical of attorneys. It was Dodge and Dunn thought that this amendment, because it prohibited titles of nobility, it would prohibit attorneys who use the title Esquire after their name, which is a title of nobility. It would prohibit them from holding public office or even voting. And they were all eager to get at the attorneys. And I'm publishing a magazine called Anti-Shyster, and they said, "He's the guy. We got to get to him." They thought I had 100,000 subscribers. At the time, I was publishing maybe 10,000 copies of the magazine a month. They had misunderstood how many people were reading my magazine, but they brought it anyway. And I wrote 3 articles on it over a period of several months. And eventually I assembled those 3 articles into a book. And it included, 60 pages, I don't recall clearly, maybe 80 pages of copies of the different documents where David Dodge had found evidence that the 13th Amendment was believed to be ratified, again, by 23 or 26 states and territories. And when you looked at it and comes, you said, look, something has happened here. Something extraordinary has happened here. Because if this was simply a mistake that propagated for at least half a century in this country, imagine you have you got 26 states and territories are publishing books that say, this is an amendment to the Constitution, and it's not so. This is a pretty big mistake. This isn't a casual thing. This isn't a footnote. This is very important information. It's inconceivable that it could have propagated for over 50 years by mistake. I won't say it's absolutely inconceivable, but it's pretty close. The reason the amendment disappeared is that it is arguably the most important amendment that was ever placed on the Constitution. Now,
Because?
because it not only prohibited titles of nobility, and that's what everybody gets excited about, we're going to keep the lawyers out of the White House and out of the legislature. More importantly, it prohibited honors. And the definition of honors at that time was any advantage or privilege that one group or one individual enjoys as compared to another. Now the reason, in other words, we can't pass a law that says Al has to pay, an extra $1,000 a year in taxes, so Bill gets an extra $1,000. Bill would have an honor if he had an advantage or privilege. It would have meant no special interest legislation. It would have meant no entitlements. It would have meant the only thing the federal government could do is pass laws that applied to everyone equally across the whole country. They couldn't grant immunities for government employees. They couldn't grant immunities for congressmen and senators. They couldn't have entitlements for minorities or women or men or anybody else you care to name. The law would have to be the same for every man, woman, and child across the entire country. No titles of nobility, no honors, no special interest legislation. That would have meant Congress would not have to meet, in my opinion, more than maybe 6 weeks a year. They could chase their pages and their secretaries for 3 weeks, and they could spend 3 weeks debating what? Maybe a dozen laws a year that would apply to everyone equally. No special interest legislation would have meant no big government. It would have meant your taxes would be a fraction of what they are right now. If the government can't use their special interest legislation to divide and conquer and take something from this group and give it to that group, the government really doesn't have much to do. So it's part of the reason why I say this is so important. Over time, a few years after Dodge went through the when he did the original research, and then we wrote up these articles and published the book and got the information out. A bunch of people jumped on this. A bunch of people. I mean, it was David Dodge and Tom Dunn eventually just kind of bowed out, and they turned the movement over to some other people, primarily out of Arizona. And again, I can't remember his name. I should be able to, but I haven't talked to him in most of 15 years, probably 10 years at least. Don't recall his name. Did some spectacular work. They tried to compel the government to admit that this was a valid amendment to the Constitution. Government stonewalled at every instance. They said there's no proof, there's no evidence. David Dodge went back to the same archives that he'd first visited back around 1989, 1990, where he'd first collected his information. He went back about 94, thereabouts. He went to the same archives, and every place he looked where he had previously found the evidence had been removed. Someone had studied the articles, someone had studied what David Dodge had reported, someone in government was paying attention, and they went to each of these archives and they removed the evidence. And the misfortune on all of this is that Dodge, when he collected these samples, these copies from all, I must have had a stack this thick of documents, photocopies, just a page or two from these documents where they had said, yep, 13th Amendment's real. None of them were certified. You look at them and you can see they're books. All right, it's not just something they weren't digital. This was before the internet. They were photocopies. They're books. You see the shadows on the books. You see the old type fonts. There's no question. And a big variety. This isn't fraud. This isn't some. This was not contrived. This was real. But the evidence has been removed, and I don't doubt the reason it's been removed is that, again, this was certainly one of, if not the most important amendment that ever appeared on the Constitution. No special interest legislation. I mean, this was their attempt to declare absolute equality across the board for everyone in the country. Huh? There would have been no advantages. Didn't matter. Were you a Wall Street financier? No big deal. You would have no more rights than somebody who's running a little farm in Iowa.